Welcome to the first of the Week 7 podcast for Administrative Law. In this podcast, we're looking at the remaining grounds of review following on from our discussion in previous weeks. Specifically, we've been looking at the grounds of judicial review under Section 5 of the ADJR Act and Section 22 of the Judicial Review Act of Queensland. In weeks 4 and 5, we were looking at the grounds listed in subsections A to D, and last class we looked at the improper exercise of power ground under section 5(1)(e) and said that this ground encompasses a number of other grounds which are listed in section 5(2) of the ADJR Act. The remaining grounds of judicial review, the error of law, no evidence and fraud grounds, are listed in subsections F to H and will be the focus of this podcast. There's also the catch-all ground that the decision was otherwise contrary to law, which we don't focus on as it's not used frequently in practice. Pretty much all you need to know about this ground is that it is a catch-all if the other grounds can't be established, but there has been a legal error. Slide 4 reinforces what we just said about the topics that are a focus of this podcast. So first, let's look at the error of law on the face of the record ground, which is a ground of review at common law and also under section 5(1)(f) of the ADJR Act. We'll look at the common law position first and then the statute law position. Remember, grounds of review can also be argued under the common law, and indeed before the ADJR Act was introduced, they only existed at common law. The grounds in the ADJR Act are a codification of the common law grounds of review, so as a starting point it is helpful to understand the common law position. Under the common law, if an error of law can be identified and it appears on the face of the record, a writ of certiorari may be issued. Remember, we said that certiorari is an order to quash a decision. In other words, a decision with an error of law on the record can be declared void. So let's break this down into its elements. First, what is an error of law? An error of law may occur when a decision maker misinterprets a statutory provision, or misunderstands or misapplies a general principle of law, or misinterprets words or phrases of a technical or specialist nature. Second, what is meant by the term record? In the case of Craig and South Australia, the High Court preferred a narrow interpretation of what constitutes the record for the purposes of judicial review of an inferior court. The record can include documents which initiate the court proceedings, the pleadings, if any, and the adjudication. So the record refers to formal final documents and wouldn't include the court transcripts, for example. So that's the common law position. The equivalent of this ground of review for the statutory avenue of judicial review is in section 5(1)(f) of the ADJR Act and section 22(f) of the Judicial Review Act of Queensland. The wording of this ground is that the decision involved an error of law, whether or not the error appears on the face of the record. Thus, the no evidence ground in the ADJR Act adopts a slightly more relaxed position than the common law because under section 5(1)(f) there is no requirement that the error appears on the face of the record. That is, the error of law does not have to appear on formal final documents such as official documents from inferior courts. This makes sense when you think about the statutory right to reasons under the ADJR Act. This would allow an applicant for judicial review to identify an error of law without having to rely on official documents from courts, etc. In addition to being a more relaxed version of the common law error of law rule, Section 51F also incorporates the previous common law test for no evidence, which we'll discuss more in a moment. Another ground of review is the no evidence ground. No evidence as a ground of review exists at both common law and under the statutory avenue of judicial review. The statutory equivalents are found in both Section 51F and Section 51H of the ADJR Act, which is a little confusing, but hopefully it will become clearer as we unpack it. Again, we'll look at the common law position first, as it helps to make sense of the statute law position. The legality and merits distinction, which relates to the separation of powers, is relevant to this ground. As we've discussed, at least in theory, there is a border between making decisions about the facts and making decisions about the law. It is appropriate for the courts to do the latter, but not the former. So the courts are not supposed to trespass on the merits of the matter by assessing and weighing the factual evidence that was before the decision maker. Although the courts aren't supposed to re-examine the facts before the decision maker, the courts have decided that a complete absence of evidence for a finding of fact is an error of law. This is the type of legal question that the courts can appropriately engage with as part of judicial review. So what does the case law say about the no evidence ground at common law? A case that states the correct Australian position is R and Australian Stevedoring Industry Board. In this case, there was an inquiry into the stevedoring industry. The inquiry could deregister employers that were unfit to continue in the business. The courts looked at one company and found some very minor infractions, such as bookkeeping anomalies and some minor problems with the sign-on sheet. These things didn't show unfitness to continue. So there was no evidence to show that the employer should not continue in the stevedoring industry, and the evidence available had nothing to do with unfitness. If there had been some evidence pertaining to unfitness, even if it was very weak, this would have sufficed, and this ground of review would not have been made out. The case of ABT and Bond, which we know from earlier in the unit, in which we discussed the jurisdictional prerequisites in relation to a decision under the statutory avenue of judicial review, tells us that a complete absence of evidence is required. So it is not enough to show an insufficiency of evidence, there needs to be a complete absence of evidence. This is where Australian and English law differ a bit. Australian law is a little bit harsher because there needs to be a complete absence of evidence, whereas in the UK, insufficient evidence will be enough to establish this ground of review. If that's the common law position, what then is the position under the statutory avenue of judicial review? As I said, the way the no evidence rule is reflected in the ADJR Act is a bit confusing. Section 51F, which we looked at before, and Section 51H sound different, but both deal with no evidence in different ways. Subsection 51F incorporates the pre-existing common law ground and the requirement of a complete absence of evidence. This is a bit confusing as this ground of review refers to an error of law and doesn't use the word evidence. Section 51H is an additional no evidence ground that is unique to statutory judicial review. And this point was made by Chief Justice Mason in the case of ABT and Bond. Then, Section 5.3 of the ADJR Act elaborates on Section 51H and expands the new ground. There is a two-part test under sections A and B, which we'll come to in a moment. And in effect, this expands the rule. The Queensland equivalents can be found in sections 22H and 24 of the Judicial Review Act of Queensland. So now we come to look at section 51H, which is called the no evidence ground, but is in fact broader and more relaxed than what no evidence means at common law and has a meaning that is unique to the statutory avenue of judicial review. Section 51H says that there was no evidence or other material to justify the making of the decision. Section 5.3 expands on what is meant under Section 51H. Subsection A says the person who made the decision was required by law to reach that decision only if a particular matter was established and there was no evidence or other material from which he or she could reasonably be satisfied that the matter was established. Or B, the person who made the decision based the decision on the existence of a particular fact, and that fact did not exist. So these are referred to as the first and second limbs of section 51H. In order to make out the no evidence ground under section 51H, you need to satisfy the first limb or the second limb. There is not a requirement to satisfy both. So let's look in more detail at the elements of the first limb. As we said, this limb states that the person who made the decision was required by law to reach that decision only if a particular matter was established and there was no evidence or other material from which he or she could reasonably be satisfied that the matter was established. The case law sheds some light on what key phrases in this provision mean, and those key phrases are underlined on the slide. The phrase "a particular matter" refers to a condition precedent to making a valid decision. As we've discussed previously, a condition precedent is something that must happen, a condition that must be satisfied before a decision is made. This won't apply if the matter is simply one of a number of considerations relevant to the making of a decision. The phrase "no evidence or other material" indicates that legally admissible evidence is not required to support the decision. The phrase "could reasonably be satisfied" means that there is no need to show a complete absence of evidence. A lack of probative evidence to support the decision will suffice, and this was confirmed by Chief Justice Mason in ABT and Bond. As I mentioned before, these statutory provisions liberalise the common law, where you need to show a complete absence of evidence to make out the no evidence ground of review. Okay. Now let's consider the meaning of the elements in the second limb, which states that the person who made the decision based the decision on the existence of a particular fact, and that fact did not exist. The phrase "a particular fact" normally means a secondary or ultimate fact, rather than a primary or evidentiary fact. The meaning of an ordinary word in a statute is a question of fact and may be established by evidence, including resort to a dictionary. This is not reviewable. However, the meaning of a term with a technical legal meaning is a question of law which may be reviewable. For example, in the case of Curragh Queensland Mining and Daniel, the particular fact in question was that the applicant thought they could negotiate a delivery date later than the one stipulated in the contract. This was an incorrect assumption about the legal requirements under the contract, and was thus a secondary fact that could be reviewed as a particular fact. The phrase "based on" means that a particular fact is critical to the making of a decision. A small factual link in a chain of reasoning may suffice for a decision to be based on that fact. It doesn't matter if it is a small fact or a big obvious fact, as long as it was integral to the making of the decision. The case of Curragh is authority for this point as well. The case of Rajamanikam was a refugee case where the matter hinged on whether there was a well-founded fear of persecution if the applicant returned to his home country. 2 out of 8 reasons establishing that there was no well-founded fear did not in fact exist. The High Court said that the other 6 factors are enough. The decision maker would have made the decision anyway based on the other 6 factors. In other words, the 2 reasons for which there was no evidence cannot be said to be critical, as there was other evidence relied upon to decide the matter. And Justice Kirby was in dissent in this case. Finally, the phrase "the fact did not exist" means that to make out this ground, you've got to do more than show an absence of evidence to support the fact. Rather, you need to provide proof that the fact cannot be established, no matter how much evidence is provided, because the fact is simply not true. As I know there can be potential ambiguity around these grounds of review, I'll summarise the key points now before proceeding. As we said, under the common law, if an error of law can be identified and it appears on the face of the record, a writ of certiorari can be issued. The statutory equivalent of the common law error of law on the face of the record ground is in section 5(1)(f) of the ADJR Act. This statutory provision adopts a slightly more relaxed position than the common law, as there is no requirement that the error appears on the face of the record. Section 5(1)(f) of the ADJR Act also incorporates the previous common law test for no evidence, as being a complete absence of evidence. Section 5(1)(h) is an additional no evidence ground that is unique to statutory judicial review. The test is not the same as the common law no evidence test, and the correct test for this ground is expanded upon in the two-limb test in section 5(3) of the ADJR Act. The next ground of review listed under section 5(1)(g) of the ADJR Act is that the decision was induced or affected by fraud. The equivalent provision is in section 22(g) of the Judicial Review Act of Queensland. Normally, fraud proceedings under the ADJR Act will occur after a criminal finding of fraud. The admin law response is then to reevaluate the whole decision if it was based on fraudulent information or processes. Accordingly, these types of matters don't make it to the courts very often. Normally, a letter drawing the decision maker's attention to the fraud and requesting them to remake the decision will suffice without it having to go through the judicial review process. In most cases, the fraud isn't by the decision maker, and it may be fraud practiced on the decision maker by a party to the proceedings or by a third party. A classic example of practicing fraud on the decision maker is where a party or a witness lies. The fraud may be practiced on the decision maker by a third party. In SZFDE, there was a person claiming to be a migration agent and a lawyer, and he was neither of the two. He told the migrant family that they didn't need to attend a hearing, and as a result, the decision went against them. This is an example of where the fraud was practiced by a third party on the tribunal. The parties, that is the family and the Minister for Immigration and Citizenship, weren't to blame for this. Accordingly, the decision of the tribunal should be regarded in law as no decision at all, as it was affected by fraud. The onus of proof for fraud requires the applicant to establish on the balance of probabilities that the decision was actually induced or affected by fraud. That is, a mere suspicion or a real possibility is not sufficient. This is, of course, difficult to prove in practice. The grounds of review for improper purpose and bad faith also overlap with fraud and are easier to establish. Unlike the bad faith ground, where the bad faith is by the decision maker, the fraud ground mostly operates where the fraud or dishonesty is practiced on the decision maker by another. If the fraud ground is based on fraud by the decision maker, it is likely to also enliven the grounds of improper purpose and bad faith. These last two grounds are easier to establish as they don't require conduct that is subject to criminal or statutory penalties. For the purposes of the admin law exam, fraud is most likely to arise in relation to fraud or dishonesty practiced on the decision maker by another. Okay, so that brings us to the end of our discussion of the statutory grounds of judicial review. Before we end this podcast, let's look at one revision question. The question is, the ground of no evidence under common law and section 51F of the ADJR Act requires A. Insufficient evidence, B. A complete absence of evidence, C. Evidence that is established on the balance of probabilities, or D. Reliance on evidence that is not logically probative. What do you think? The answer is B, and we know from the case of R and Australian Stevedoring Industry Board that a complete absence of evidence is required for section 51F. A is incorrect. This is the case in the United Kingdom but not in Australia. C is not the correct test, and neither is D, but D is relevant to the test in section 51H that is elaborated in the first limb of section 53 of the ADJR Act. This brings us to the end of this podcast. In the next podcast, we'll look at the important topic of jurisdictional error.